Roberts first.
Thank you, Chair, and thank you all for coming today. Are you aware that there is a large coal mine in the Hunter Valley that is deliberately exploiting and defrauding workers of their entitlements? This deliberate exploitation of hundreds of coal miners, with the full knowledge of the major Hunter Valley branch of the major Australian coal union, the employers, a major multinational employer, a major multinational labour hire firm, and with the disregard of New South Wales ministers in the past, is astonishing. The dishonesty is both audacious and callous. Is it true that the Fair Work Commission is the organisation where disputes related to long service leave should be brought?
It would depend, Senator. If, for example, under the terms of an enterprise agreement, long service leave was a matter dealt with in the agreement, then the disputes procedure under that agreement may enable disputes arising, including in relation to long service leave, to be referred to the Commission.
Thank you for that. Are you aware that not only are these casual coal miners being massively underpaid, they are denied equivalent entitlements such as sick and holiday leave, redundancy and penalty rates for shift work, and while their full-time counterparts working side by side receive their long service leave after 8 years, these so-called full-time casual workers whose actual hours worked are severely underreported to Coal LSL rarely attain long service leave, as casual employment allows immediate terminations and intimidation, and fatigue from ill treatment and burnout from limited time off cause many miners to leave the industry. Does the Fair Work Commission deal with issues that relate to casual employees working as miners in the black coal industry in New South Wales?
I'm not aware of the particular case that you're referring to.
Would you like my office to give you a briefing?
Well, let me kind of explain the role of the Commission in those cases. In view of the Chair's comments, if we could make it very brief. So the role of the Commission would essentially be to determine the terms in the modern award, in the relevant award. So that would go to casual employment and other matters after hearing parties, and secondly, dealing with disputes that arise under the award if that's what the disputes procedure provides.
How can this be when the Black Coal Industry Award does not allow casuals in the black coal industry other than as office administrative personnel? These people I'm talking about, hundreds of people, are working in production, side by side with full-time employees, doing the same job, same skills, same qualifications. They have an EA, an enterprise agreement, that was approved apparently by Fair Work Commission, and yet the EA cannot be less, correct me if I'm wrong, the EA cannot be less than the award in terms of employment conditions. An employment classification that is not in the award, casuals, cannot be added to an enterprise agreement. That leaves the employee worse off by far. These people are 40% underpaid. They're far worse than if they were covered by the BC Black Coal Mining Industry Award. No annual leave, no sick leave, no redundancy, no accident pay. How can that be?
Well, the requirement under the legislation that the Commission administers in terms of the comparison is that any agreement, any enterprise agreement, must provide, amongst other things, that each employee covered by the agreement will be better off overall compared to the underpinning award.
Are they better off when they have no annual leave, no sick leave, no redundancy, a lower pay rate, no accident pay?
I think Ms O'Neill just need to finish her answers, if that's possible.
I can't speak hypothetically. If there's that is the requirement of the Commission in considering whether to approve an agreement. I don't know. There are appeal mechanisms available if there's been an error, but on the face of it, I've got no reason to think that the agreement doesn't meet the statutory criteria.
Why would Coal LSL have referred people employed as casuals in the coal industry to bring their complaints to the Fair Work Commission, as has happened in the past?
Senator, I'm sorry, it's just really difficult in an abstract
would you like our office to give you a briefing?
Or perhaps we could put maybe some questions on notice to that might assist the witness to have some more time to respond to.
I'm asking for general responses, Chair. So, for example, one of the miners appeared at the Fair Work Commission in front of Deputy President Hamburger nearly 2 years ago. We can get the documents to you if you'd like them. And reportedly, Deputy President Hamburger signed off on many of the same EAs, enterprise agreements. So why has the Fair Work Commission in the past refused to assist casual workers in the black coal industry? As I said, coal miners doing the same work alongside the people classified as full-time workers, doing the same rostered work hours. How can that be?
All I can say, Senator, is members of the Commission, in determining the provisions in the award, follow the Act, and similarly in approving enterprise agreements, ensure that they meet the statutory tests, which include the BOOT, the Better Off Overall test.
As a casual, about 2 years ago, a casual worker provided formal written complaints over a period of 12 months. The then Employment Minister, Michaelia Cash, advised him to go to the Fair Work Commission. The Fair Work Commission said, yes, I'm quoting him now, we identified an issue exists, but would not intervene because he had legal representation. Then this miner had a phone conference with the Fair Work Commission to get accident pay. He requested his full accident pay, and the Chandler McLeod group refused. At that point, the mediation ended, and the Fair Work Commission said there's nothing more that they can do. People have been abandoned in the Hunter Valley.
Again, Senator, I'm sorry, but in the abstract, I really can't add to my answers.
How many disputes from 2016 to date involving Chandler McLeod Group have been brought by coal miners to the attention of the Fair Work Commission involving complaints about coal LSL, long service leave entitlements, and have they all been resolved? You probably have to take that on notice.
I'm happy to take that on notice, Senator.
How can two people doing the same production job, same roster, be paid so differently? How can one be casual and the other full-time?
It depends on the terms of the award and agreement that applies to their employment.
Would you like my office to bring material to you, documents?
Well, I'm not rejecting your generosity. It's just that I'm not quite sure how that would assist, given the limited role that the Commission has. But perhaps,
in what way is it limited?
Well, in the way that I've described, it's in terms of dealing with disputes that arise under an agreement, and it's not appropriate for. It's a tribunal, and so it deals with matters through applications that are lodged and dealt with in an open and transparent way. So taking information outside those processes is not straightforward. But what I'm suggesting is that if I deal with the questions that I've taken on notice, and if in the course of those further information would be of assistance, then would be happy to provide that.
Perhaps you can get one last question.
One last question, thank you.
Perhaps you could give me some advice then, or give these miners some advice. The CFMMEU says an EA must expand, as in having superior entitlements on the award. The CFMMEU has not done anything about this atrocity. The major employer, major multinational, Australian multinational, has done nothing. It condones it. It knows what's going on. The major direct employer, the labour hire company, a major multinational company, is aware of it. And the Minerals Council of New South Wales is aware. Have you got any advice as to where these people should go next?
Not at this point, Senator.
No, they've been failed. They've been failed by everyone they've approached. They've approached all these people.
Well,
thank you very much, Chair.
Senator, I appreciate your time, but in terms of some of the issues you raised on notice, or perhaps to the Fair Work Ombudsman, indeed, in terms of the issues, but I'll hand over to